Top of the morning to you. It's a beautiful day. I'm trying this again. My dog is very excited this morning. There's lots of bicyclists going by and joggers, all sorts of wonderful things, and he's very, very excited. Obviously, the topic of the discussion this morning for Ramblin' While Amblin' is going to be Mr. Warden's lawsuit. I want to start off with two things. First of all, I have always stated and always maintained and still state and still maintain that the arrest was probably a bad arrest. It was a terrible arrest. I think Mr. Warden should have won his original trial. I think it was silly for Mr. Warden to have let that one go by without hiring a lawyer, especially considering that Mr. Warden wanted to sue based on false arrest, false imprisonment, unlawful detention, etc. I think that was a tactical error by Mr. Warden. And I think it's like a baseball player allowing a strike to go by simply because he doesn't want to swing at the first pitch. It was a tactical error. So, beyond that, good morning. Hello, puppy. Good morning. All right. So I think it was a tactical error. Now, as far as Mr. Warden's pick for an attorney, that attorney looks amazing. That would be exactly the attorney that I would hire. And whatever criticisms I had of the complaint that attorney filed weren't criticisms of that attorney's skill. It was saying that it's a very bare bones. It's enough to put opposing counsel on notice as to what the eventual suit may be over, but it was still, it was pretty barren of actual facts. And I'm assuming that's because that attorney is going to need to get those facts. So again, assuming that attorney is working on an hourly basis, that attorney did exactly the right thing by not spending a long time trying to figure out facts to put in there and figure out causes of actions to put in there. It's poo-poo time. Oh boy, you're gonna get a pocket here, folks. It's poo-poo time. All right. What's going on? I don't even know. All right. We're good. I have achieved poo-poo-ness, and we are back rolling. All right. So, the attorney. Exactly the right attorney. And probably doing exactly the right thing. The claim, again, kind of bare bones, simply to allow for whatever information comes out in discovery to be filled in at a later date. So I do expect there will be amended complaint or amended complaints. The issue with adding the U.S. Army and the Department of Defense, I think that's Mr. Warden once again blowing sunshine up our skirts, because that's Mr. Warden's MO. He is loose with the truth, and that's all I'm going to really say about that. Like with the firearm, he's very loose with the truth. But that's not the attorney's fault, and Mr. Warden recommending to his attorney that he include these people, I'm sure that his attorney has advised him appropriately that a respondeat superior 1983 claim isn't going to attached to the Department of Defense, and etc. So that's a failing, I believe, on Mr. Warden's part, not his attorney's part. I haven't seen his attorney add these people, add these groups, etc. So we have an attorney with 20 years of tort experience. People are saying, oh, he's an ambulance chaser. Well, here's some news for you folks. The guy has practiced in front of several district courts. I think the list was about 5 or 6. He's argued in front of courts of appeal. You only get admitted to those particular bars by having to actually argue in front of them. So that means that he at least argued one case at a minimum in front of each of those. But the bigger deal is a tort is a tort is a tort is a tort. If you can write a complaint about torts, if you can successfully prosecute a tort case, then you know how to do torts. Was there a duty? Was there a breach of the duty? You know, was the complainant harmed by that breach of duty? It's a very simple process. It's a very simple deal. And suggesting somehow that because an attorney specializes in that area, it's a lucrative area to specialize in. If somebody is injured in an accident, they don't have to put a whole lot of money down to get an attorney, because that attorney will work on contingency. So, you know, you pay court costs probably, and at the end of the day, when the case is settled, then the attorney will take his cut out and give the client the rest. And it's a lot easier to get people to sign up for those than it is if you're telling this client that they have to lay down, you know, anywhere from $1,500 to $10,000 to get the case brought to trial. So, again, I think the attorney is an appropriate choice. Good morning. He's an appropriate attorney. He's well qualified. He has a long career in the right field. Doing torts. I have no issues with that guy at all. Now, Mr. Warden wants to know what I would have done differently. There's not a whole lot I would have done differently. I don't have access to all the facts. And this attorney also doesn't have access to all the facts. He doesn't know exactly if and how the chief of police was negligent in hiring Mr. Rufus, or negligent in equipping Mr. Rufus, or negligent in telling Mr. Rufus what the policy is and how to achieve those policy goals. That's why it was a fairly broad-brushed complaint. Until you get those facts, which is why I was saying that he was going to wait till discovery to get those facts. Until you get those facts, it's got to be a very broad-brush complaint, sufficient to put the opposition, the opposing counsel, the opposing party on notice of what you're going to be suing about. So there's nothing, it's not like I don't know if you noticed the difference between what I did with the Leon Valley complaint, what I did with the Chauncey paperwork, and what I did with this complaint. This complaint, I didn't say anything at all about the form or function of it, except for the slight inconsistency on claiming that Rufus Jones at all times was acting as a police officer for the city of Pineville, while at the same time maintaining the claim that Rufus Jones banned Mr. Warden from all military bases. And yes, I'm aware that Rufus Jones is a sergeant or a sergeant major in the Louisiana National Guard, but that does not, however, give him the authority to ban Mr. Warden from all military installations. He just doesn't have that power. So I have a feeling that that's something that the client really wanted brought in there that the attorney knew or understood. Is not. But sometimes, you know, you just got to add what the client wants because it's the client's suit. Oh, this is going to be fun. This is going to be fun. Anyway, so I'm not saying it's a losing lawsuit. At the end of the day, though, I do think it's very important for Mr. Warden to win on his appeal. That's step number one, because it's going to be very hard to say it's not impossible, but it's next to impossible to prove by a preponderance of the evidence that the arrest was unlawful if there's a conviction on the arrest. It's not impossible, but it's very hard to do. So I would suggest to you that that's going to be step number one. Step number two is then going to be getting that discovery process going and getting some of the background information that Mr. Burgess is going to need in order to fill in those details. And he couldn't get that information prior to filing the suit because discovery doesn't start until the suit's filed. So there you go. So I'm not saying it's a bad lawsuit. I'm not saying that Mr. Burgess is a bad lawyer. I'm saying that Mr. Earl David Worden screwed up by whiffing at the first trial. And I'm saying that Mr. Earl David Worden is whiffing when he thinks that he's going to somehow sue the Department of Defense and the U.S. Army. And those are Mr. Earl David Worden's failings, not Mr. Burgess's failings. So I hope I've made it clear. I don't think this is going to be some grand win for First Amendment auditors in general. It's not going to establish precedent on anything. You may have noticed that there was no claim that Mr. Earl David Worden could film a military installation. And indeed, it might be brought up that it is, what is that, 18 U.S.C. 795, the filming and installation, that might be brought up as a defense. So who knows? I mean, this is a brand new lawsuit, and it is subject to change, amendment, and I would trust the attorney with 20 plus years of experience in torts as my attorney. And I think Mr. Worden is doing right by hiring an attorney of that caliber. So there you go. Thanks for watching. Have a great day.